Hi, good afternoon, everyone, and welcome to the session on the Public Procurement Act, or more specifically, navigating the Public Procurement Act. I'm Nathan Ross Adams, and I'm the founder and MD of IT Law Co. We're an organization that really helps the world's organizations and governments leverage technology safely, lawfully, and profitably. And one of the areas of speciality that we focus on is procurement law, and in particular, IT procurement. So for today, we'll be looking at the recently enacted Public Procurement Act, what it means for you, and much more. Feel free to pop your questions in the Q&A section of Teams. Also, the session is being recorded. You will receive a copy of the recording once the session has completed. So to get you started off, I am going to share my screen. Okay, great. So, today we're going to be talking about South Africa's new Public Procurement Act. We have quite a bit of information to go through, but I've put it in plain, simple language, so it should be understandable, but it is pretty dense. So, brace yourself as we go through. And if you want to follow the different sections of the Act, please go to publicprocurementact.co.za and it will give you the Act in its totality. Now, the Act hasn't been out for a long time. I mean, it was signed into law on the 24th of July this year, and it's already garnered mixed responses. So some people are excited about it, saying that public funds will finally be directed where they're needed. Others are saying it could facilitate state capture 2.0. The DA and Cape Town mayor has specifically asked them to halt the Procurement Act. The reason for that is because it extends to municipalities, local government, and at a provincial level, because they believe it could hinder service delivery, and then several other opinions on the topic. So it is pretty topical right now. But what you'll get from today's session is really an understanding of the PPA, or Public Procurement Act. You'll know its purposes, key rules, and how it will affect South Africa and South African organizations that want to do business with procuring institutions in South Africa. We'll also be able to see its benefits and disadvantages, and then you'll also get a cursory understanding of the actions that you would need to take in response to the Act. Again, feel free to pop or ask questions at any time. If you can do so in the Q&A session, but you also feel free to raise your hand at any point. So it's important to paint context at the beginning of each, I'd say, session, because it frames the conversation in a way that's pretty meaningful. Actually, just before I continue going ahead, could someone give me a thumbs up if they could hear me clearly? I see there's one participant that is not getting any sound through. Okay, great. Okay, so why does South Africa regulate public procurement? From a policy perspective, it's really the ideal, I'd say, is for procurement to happen in a fair, transparent, and efficient way. And South Africa has its goals as a country. This is typically known as grand strategy, where a country indicates where it will direct its spending. And so we have national goals, and part of those goals are socioeconomic development and good governance. And so this is generally the concept behind public procurement, but we do have a fragmented legal framework currently. So what you see on the screen is just a snapshot of the varying laws that impact public procurement in the country in one way or another. It starts with the Constitution, Section 217, as well as various court cases or common law, judge-made law that gave interpretation to it. And then there are the statutes or formal laws supported by regulations, like the Public Finance Management Act, the Preferential Procurement Policy Framework Act. Over here, you also have the Municipal Finance Management Act, the Prevention and Combating of Corruption Act, the Broad-Based Economic Empowerment Act, PAJA, or the Promotion of Access to Justice Act, PEPUDA, PAIA, POPIA, and then also the Competition Act, which is often overlooked within this context. The point is that up until now, all of these laws needed to be considered when an organization would, for example, consider submitting a bid to a procuring institution or an institution in the public sector that would release a bid. And the Public Procurement Act has effectively come along to say that, well, look, we need to address this fragmented legal framework and have one source or a main source of law regulating procurement in the country. The Act's objectives are really to focus on standardization. So as I mentioned, a uniform framework, but also to deal with preferential procurement, where certain businesses like SMEs or local businesses would be favored, or historically disadvantaged groups. So people who were discriminated on the ground of race, gender, for example, those are all considerations. But at a more granular level, the Act ties into this idea of creating efficiency and value, promoting anti-corruption, economic development, efficiency and tech, dispute resolution, and then sustainability and innovation. And these are all admirable and laudable goals or objectives to work towards. But practically speaking, what does that mean? I mean, those goals are very abstract. Yes, we can all agree that the country should head towards that, but isn't this just another situation of more red tape for people to complete? And I don't think so. I think the Act does a good job at consolidating all areas of law and dealing with the different areas, as we'll get into now, that was previously fragmented. And then, as you'll see a bit later, the Act also takes precedent in event that there's a conflict between the Act and any other existing procurement law. And at the end of the Act in the schedule, you would see, if you go to the website and you click on the schedule over there, you'll see that it repeals or ends legislation that currently governs procurement. From a compliance perspective, we are really considering, well, when is it going to start? So currently the Act has been enacted or signed into law. That happened on the 23rd of July this year. But this is really the date that it means it is a law. When the law actually is going to commence is unclear at this point. It would likely be a political decision after consultation with the Government of National Unity, but we do not have a predicted date for it to be implemented. But the idea is that it will definitely be implemented. There are certain organizations that want to do a constitutional challenge to this law based on its preferential procurement framework. But based on what I've seen, it's unlikely to succeed because the Constitution does allow for preferential procurement. In fact, there's an obligation on the state to cater for preferential procurement. I've been throwing this word around a lot, procurement, but it has a very specific definition within the context of this Act. So you'll see that it deals with the acquisition of goods and services for various projects, construction, repair and maintenance, or capital assets. And then it goes into general acquisition of goods and services. Then acquisition of infrastructure as well, or other capital assets, and then the letting or disposal of assets. So in other words, hiring a property out or selling assets that belong to the state. And this really is by a procuring institution. Now, you may wonder who the Act applies to, and generally it applies to government departments, the constitutional institutions, municipalities, and public entities. However, there are instances where Parliament and provincial legislatures need to comply with the law. And generally speaking, it covers all procurement activities, regardless of whether the funding was conducted by state, so if it's out of public funds, or whether it's a project-specific matter that's funded by a donor. So, for example, the German International Agency spends a lot of time or a lot of resources driving policy within the country, and so even if they fund it, it still falls within the scope of the Act. Again, it applies to all bidders and potential bidders and anyone acting on behalf of a procuring institution. And I should say that a procuring institution really is any one of the departments, institutions, municipalities, or other entities that are listed here, or their agents, so people acting on their behalf. I mentioned this early on, but really, if there's a conflict between the Act and other laws, this Act takes priority. In other words, the intention of the legislature was to say that we don't want people to have to consider various other laws in managing or responding to bids. We want them to focus on one, we want them to have one source of law. And so that's the Act's intention with this section. And then from the administration side, it falls within the Ministry of Finance. Now, what you would see on the screen over here is a list of various role players that I've identified in reviewing and engaging with the Act. As you can see, there are quite a few of them, but I've grouped them according to how closely they are linked together. And so you'll notice on the left-hand side, we'll have procuring institutions, and the officials related to who work for those institutions, and then the financial roles that are performed within the organization, so accounting authority or accounting officer, as defined in the PFMA. Then you'll have bidders, bid committees, suppliers, related persons. So bidder is when you would submit a bid. A supplier is actually once you've actually been awarded the bid. Related persons are companies, organizations related to you. Bid committees are within the procuring institution, and then immediate family members refer to the instance where there would be someone who is an immediate family member of yours that may be within a specific government department. Above, you would see what really happens at a top level, and that's that the Minister of Finance, as well as National Treasury and provincial treasuries, have a very key role to play in the administration of the Act. And it does something unique in that before the mandate for procurement law was set really at a national level, and at a provincial level, as long as they subscribe to similar principles, it was okay for them to decide on their own procurement steps, right? However, that changes with the Act in that the municipalities, local government, provincial government can create their own rules, but those rules need to comply with this Act itself. So it sort of unifies from a national to a local government level what is required. There's the Public Procurement Office as well, which we'll get into detail later about. And then really there will be a Public Procurement Tribunal that will deal with disputes, as well as on the left-hand side, the bottom left corner, you would see various categories of people that would benefit from the Act's preferential procurement framework. In the next few slides, we will be doing a deep dive into the various areas of, or the various role players, as well as the different sections of the law itself. And really, one of the key features of the law is that it establishes a public procurement office. And the intention behind the establishment of this office is really to provide effective implementation and compliance with the PPA, or Public Procurement Act, across all procuring institutions. So I want you to think of it similar to the information regulator that deals with data protection and access to information in South Africa, or the competition tribunal that gives effect to the Competition Act. So it will be a sort of creature of statute in that the law has created it, but its core functions really include what's listed there. Um, and so from a promotion of compliance perspective, they need to ensure that the procuring institutions, so the companies or the state entities that put out bids, comply with the Act. Then maintaining integrity, the office needs to establish measures to prevent corruption and uphold integrity. And so anti-bribery and corruption is central to this law, and organizations need to respond accordingly, would need to, by demonstrating that they actively have an anti-bribery and corruption program, which aligns with the law and any guidance that this office may release. On a guidance and support front, really, they'll probably issue guidance notes giving effect to the different provisions of the Act on specific topics, such as, let's say, government has a priority of increasing infrastructure in the country. They could release a specific guidance note that would apply to critical infrastructure and how procurement relates to that, and whether there may be any relaxation of rules to actually deal with it in that context. Transparency, standardization, many of these others will come up as we go along, but the gist of it now is that there will be a single point of contact for dealing with the implementation of this law. In addition to those functions, they do have powers, and so this is authority that's granted to them by the law, where they can issue non-binding or binding instructions to procuring institutions, essentially telling them what they can and can't do. The same with non-binding. I've mentioned some of the guidelines, and then also determine model procurement policies. So in other words, set the standards and guidelines for which state entities actually need to comply with. From a provincial treasury's perspective, so we do have national treasury, which deals with the financial matters of the state or South Africa as a whole, but you also get provincial treasuries, which focus on the administration of finances from a provincial level. And really their role is their oversight, support, flexibility, and leadership. And what this would include from an oversight perspective is really monitoring the procurement institutions within the provinces, ensuring it's well managed, and set up plans and actually effect those plans in fixing serious problems with procurement and prevention of access, for example. From a support perspective, the provincial treasuries also need to support the Public Procurement Office with any information they have, any tasks they're assigned by law, and they also need to offer guidance to municipalities on their procurement processes. And from a flexibility perspective, really, this is what I was talking to about issuing, having the flexibility at least to issue guidelines to municipalities to effectively help them apply and interpret the Act. And then lastly, from a leadership perspective, the head of provincial treasuries effectively have the authority to act on behalf of the whole treasury or the entire treasury in this matter, which is pretty significant. But let's move along to a concept I've been mentioning quite repeatedly, and that's procuring institutions. So these are the government departments, constitutional institutions, municipalities, and the public entities. And the question is, who makes the decisions? So who is ultimately, who does the authority lie with, and who ultimately has the final say? And this is really the top financial person in these institutions, which are known by law as an accounting authority or an accounting officer. And they're responsible for making the procurement decisions under this law. They need to follow the law when acquiring any goods or services. They need to create an effective system for procurement. And in this regard, what I'm predicting happens is that they align with a standard like one from ISO that deals with procurement, or they would turn to neighboring jurisdictions to get guidance on that. They also need to clearly define the scope of the bid. They need to provide all info, and they need to prevent misuse. So that's an active obligation to prevent misuse of the procurement system. And then they also have the authority to fix mistakes in procurement. So, for example, if a bid is sent out with legal or factual errors, or if there's fraud, they have the authority and the responsibility to fix those. Now, from the next part of the Act specifically focuses on procurement integrity and debarment. And this is really looking at the sections that promote those values of integrity, and when someone doesn't meet that, how they could actually be banned or debarred, in the words of the Act, from submitting bids. And so these principles and rules really consist of what you see on the screen. In brief, the codes of conduct deal with codes that need to be set for procurement institutions to follow. And if officials within the Public Procurement Office or the procuring institution, the government departments, constitutional institutions, municipalities, and other entities, if they break the law, in these cases, it could lead to disciplinary action for them, and likely would. And then really from how people in procurement should act, here we're looking at the conduct of procurement persons, and really the obligation that the Act, or obligations the Act imposes on them, is to act fairly and carefully, not use their position for personal gain, not interfere with procurement, etc. And these do result in offenses or crimes under the law, which we'll get into a bit later. Then undue influence and conflicts of interests are equally important. So government bodies or procuring institutions have the obligation to conduct third-party risk management, or assess their vendors, their officials, to evaluate whether they have any conflicts of interests. And if they don't declare that, they need to be held accountable for that. And that applies to bidders as well, and decision makers. And then there are some sections of the law which deals with automatic bans from bidding. So certain people, for example, government officials, their close family, they cannot bid for contracts, and the companies that they have ownership in, majority ownership in, or that they connected with, cannot participate by default in the procurement process, which is a deviation from how things are traditionally done, in that it directly sets out and calls out who can and can't be involved in the procurement process. The next section of the Act deals with the preferential procurement side of things. And the gist of it is that governing bodies need to have a policy, and government bodies, and then in this case, the government bodies are the procuring institutions that deal with fair discrimination. They need to set aside some bids for certain categories of people and use pre-qualification criteria to favor them. This section in particular is concerning for in reviewing a lot of the media coverage out there. This is really the concern with the law, in that there are instances in which it can prioritize um, fair discrimination over organizations who are fully equipped to perform those. And so there's a risk there that pre-qualification criteria could influence the nature of work that's actually produced. And so there is commentary for this section to be reinterpreted in a way, or read in a way, that this is only done secondary to the competency requirements in specific bids. And then also there is a requirement for buying local goods, or in a lot of the words that are put out there, proudly South African entities, and particularly SMEs. As you'll see on the screen, Black-owned business, women-owned businesses, SMEs, departments or procuring institutions will have targets for those, which means that they need to set targets. They would need to set the targets, and if they have no specific targets, that doesn't prevent them from setting those requirements in bids. In other words, they can do it in an ad hoc or haphazard fashion. Now, here's also an interesting part for preferential procurement, and that's really about pre-qualification. So checking who can bid. And this is also another area which is particularly concerning to many practitioners, and that's that if you don't meet those basic criteria, and I'm not talking about criteria in the sense of competency or being able to deliver the work or have a track record, I'm talking about the fair discrimination criteria or preferential procurement. You could be automatically disqualified, which is the flip side of the mandate that was released to government departments, I think at the beginning of this year or last year, where they specifically indicated that companies can't automatically be disqualified because they can't claim the specific BEE points. Now, it is a tough situation because procuring institutions and government is faced with the challenge of, we need to get the work done. We have a long way to go in things that need to materialize. So how do we do that and still open up opportunities? In my view, one of the ways that this could be supported is really through public-private partnerships, where there is where the vendors come on board, dominant vendors, team leaders, as they may say it, and then portions of the work could be subcontracted to entities who are up and coming SMEs, but who meet these criteria. And there is a possible way of interpreting the Act in that way, but we'll get into that a bit later. So there's the subcontracting side of things. Local government, which I've addressed already. And then, which is something which is particularly new to the procurement legislation. And I need you to bear in mind that most of the procurement legislation that we currently have in place arose between a period of the late 90s to the early 2000s. And so it really is, if you look at those laws, it's a snapshot of that time period. Whereas now there is a move towards sustainability, job creation, and local development, which is entrenched in this law or made as a priority. So these sustainable development goals can be set as goals in documents. And the practical impact of this is that bid documents, so the documents you would typically receive from governments on, let's say, the e-tenders website, they would look different. They would have different ways of approaching them, and so they'd require a different approach to submitting bids. In helping various clients, particularly within the IT sector or ICT sector, What they are doing in response to this from a practical perspective is that they're taking the Act's requirements and then they're mapping it to the current procurement processes, and not procurement, but rather bid submission processes. And so instead of starting on zero, where they're looking to fully jump in and comply with this law, they are looking at what they already have in place and using that as the foundation, and then adding the sort of remaining 20% or 30% that is unique and new to the specific law. And that's just a practical way that this could be dealt with. Um, what's also interesting to see is whether contracts between government departments that are eventually signed with a supplier or successful bidder could override some of the could override or delay some of the requirements in the act, and but that would be something that we need to wait and see. I know I've been giving you a lot of information so far, and there's more to come, so brace yourself. But what I'd say for now is really we've looked at the purpose of the Act. We've looked at the basic institutions, organizations like the Public Procurement Office, the procuring institutions, National Treasury, provincial treasuries, and their functions. Now the focus really will be moving to the actual procurement system that the Act expects procuring institutions to implement. And so these will be systems, methods, and more rules. And essentially, the law, as it currently is, states that there will be set rules for how procurement needs to take place. But interestingly, procuring institutions can also buy from each other under certain rules. In other words, if one department needs to let a premises and another department has a premises available for rent, they could enter into agreements with each other. But then you still need to take steps to prevent breaking the law or corruption. These procuring institutions can reject or cancel contracts if there's wrongdoing. So typically in contracts, in the termination clause of the agreement, it would either say termination for convenience or termination for breach. And what this effectively does is codifies a right to termination that will automatically be included by operation of law. That authority to do so will be included in the contracts that a vendor or supplier would provide, on the basis on which they would provide it to the government. And then also bid committees will have specific rules and membership requirements. And by bid committees, I mean committees within the, let's say, government department, the Department of Home Affairs, Department of Science and Innovation. They'll have specific bid committees that help out in that context. Now, this is the part of the Act that I'm most excited about, and maybe I'm biased because I practice IT and AI law quite often. But the procurement side that encourages the use of technology is novel. And really, what it says, the Act says, is that government will develop a computer system for making procurement more efficient, transparent, and less prone to corruption. And so, what this essentially is a portal, and a website, and a tool where bids will be submitted. Could effectively be submitted online, eliminating the need for actual physical documents. There will also be data that will be shared across departments and rules and procedures for the procurement methods, as well as providing transparency or reporting tools for procurement activities. So think of it as currently, if you go to the eTenders website, you would notice that I think it's the third column that specifically speaks about procurement data. Who got awarded bid, who got awarded the highest bid, which categories of people got awarded the bids. And so there is a more data-driven approach, an open data-driven approach, which is pretty commendable in terms of this act. And the thinking behind this is there'd probably, and this is an opportunity for one of you on the call, there would be an opportunity for a vendor to come on board that would actually provide that service to government. And effectively, this would provide an almost immutable or fixed trail record of the entire procurement process. So from when a bid is released to when a bidder needs to submit bids to the relevant procurement institution, to who the review committee for that is, when the decision was taken to award the bid, who the decision was awarded to, and the value of the deal, for example. And that will influence it will provide rich insights into what is actually happening and provide visibility and transparency, and ideally combat corruption in a way that's more effective than the Prevention and Combating of Corrupt Activities Act. Then also, which I find pretty ambitious, is really the establishment of an online marketplace for goods and services. So what I think they have in mind, based on reading the Hansard or parliamentary notes on this, as well as interacting with various organizations that have lobbied for this, is that the government intends to do something similar to, let's say, Amazon or Takealot or Facebook Marketplace, where vendors can register their goods and services on that platform, or like as the Microsoft Azure store, and then if someone is in need of particular services or procuring institution, they could effectively facilitate that transaction through the platform. Pretty ambitious and will take some time to implement, but it is a good direction forward. Critically as well is that the government does require that it be pretty secure. And this is where I believe data sovereignty and data localization will play a key role. In other words, that the data is hosted and kept in South Africa, and that the vendor that will provide the system, or if it's government themselves, will have effective information security measures, or what's known as technical and organizational measures, to protect this data and the entire process. Now, there's also an affirmative obligation on procuring institutions to use technology as much as possible for procurement, and government will also need to set requirements for this and for data analyses. So the government is not only saying we will be moving to this online system, it is saying you need to use this system at the end of the day. And so the intention is that it will lead towards more transparency. There are quite a few provisions as well that deal with access to information. And really, the idea is that the government wants to encourage transparency. So the public, civil society, media, and certain watchdog organizations could effectively have visibility to what's going on. However, access will be limited for sensitive types of information. And there will be guidance notes on that. But generally, an important point over here is that there are certain, so under data protection law, or POPIA specifically in South Africa, there are specific provisions about when data can and cannot be shared. And so you need to have a lawful basis or legal basis for transferring personal information from one person to the next. And in this case, the Act effectively creates one like that and says that the Public Procurement Office can share information with certain authorities like SAPS, for example, or SARS, or matters that are in the public interest, and also for national security reasons. So in those instances, the information that's submitted that may be sensitive or confidential of a business could be shared with those institutions. But certain types of confidential information can't be, or certain confidential information can't be shared, except for specific reasons. Now, from well, So now we've looked at the entities, the procuring institutions, the rules that they need to follow, this drive towards innovation and technology, and the sort of awarding process. Now we'll be moving on towards, well, say a bid's actually been awarded to someone, what needs to happen over here. Sometimes there are people who are unhappy with the result of an award of a tender, and this could either be for valid reasons, like there's tampering or interference or corruption, or someone just may be unhappy that they didn't get the bid they thought the best candidate. And so the Act establishes certain rights for bidders where they could request that the procuring institution reconsider the decision, and they need to usually do this before going to court or the Public Procurement Tribunal, which we'll get into soon. There's a time period for doing so, and really they'll investigate the decision and make a ruling on that within 30 days. And if they do decide to change their mind, they can actually cancel the contract that they've already signed with the original winner of the bid, so the supplier, and that winner also has the right then to appeal that cancellation to the Public Procurement Tribunal. Now, the tribunal itself is a new body which is also established by this law. So we had the Public Procurement Office, and now we have the Public Procurement Tribunal. The Public Procurement Office focuses on the administration and implementation of this act, whereas the tribunal will deal with disputes. And so they can reconsider who won a bid, they can ban a bidder or supplier, and really the intention is that they are independent and impartial. The law as it is today states that the tribunal needs to consist of a retired judge, legal professionals, and procurement professionals. I'm not going to go into the detail too much of who can be a member and the components of it, but really the important point is that they'll get money from public funds, and they're also entitled to charge fees. They also have the authority to acquire staff. Now, from a tribunal perspective, they can create panels that need to make decisions if there are various appeals that take place, and those will rules for those at least will be published in the Government Gazette. They also have the ability to review bans, which is really important. So say a procuring institution bans a supplier from operating or from submitting a bid, that decision to ban can be reviewed, but that will need to follow the ordinary processes in doing so. Now, here's the key part, and it's always the money conversation. There is a fee that is required to ask a tribunal to review a decision. Many view this section as exclusionary at face value because if you're an SME and the process is going to be pretty expensive, it doesn't seem likely that you'll have access to justice. However, as far as I can tell, based historically on similar laws, government hasn't tended to make this cost very high, and it's usually dependent on the turnover of the particular supplier. But otherwise, yeah, the review process at the end of the day is enabled or is in place to ensure that there is effective access to justice, as well as that disputes could be resolved in a way that gives effect to the act. But again, they will be procuring, they will be creatures of statute. So there'll be entities like the information regulator, like the competition authority, like the Film and Publications Board, which are effectively created out of laws. And so their decisions as well can be reviewed by courts if you're unhappy with it. These are just an indication of the various review processes. Bidders can, or the tribunal can agree with the procuring institution's original decision, they can send it back for reconsideration. They actually have the authority to halt the contract that has been awarded by a procuring institution, which is interesting because from a contractual perspective, they're effectively given the authority to invalidate a contract. Effectively, they're in contract with procuring institutions. This tribunal, there's a right to cancel it, which becomes automatically, by operation of law, part of the award of the contract. And so when you do consider doing work and when this law activates, it's worthwhile to consider what the financial commercial impact would be of that on your organization and what the risk associated with that would be, and consider whether there is any sort of recourse for you in the form of insurance or claims. Now, when disputes take place, the procuring institution may not sign the contract for 10 days after after the tribunals reconsidering their decision. If the case goes to the tribunal, though, this process halts the time period and also authority of that procuring institution when it comes to contracting. However, there are exceptions, and this will apply particularly in the case of critical infrastructure, in the case of when there's an emergency requirement. So for example, I'll give you a practical example here. The Department of Correctional Services has currently been bidding for months on end to get fingerprint scanners for police stations, for prisons, to actually scan people's fingerprints. However, they use a very specific device that no vendor in South Africa currently has stock of. In fact, there's only a company in the EU and in India which has the technology, and based on the volumes that they require, it really doesn't make financial sense for local entities to facilitate that. However, the fact is it is an emergency bid. The point is that it's an emergency bid, and so they can, similar to that process, dispense with the rules for an emergency procurement process. But the different procuring institutions would need to set guidelines for that. Or sorry, the Public Procurement Office would need to do so. Now, we've spoken about the Public Procurement Office and the Public Procurement Tribunal. If we look back at the Procurement Office, they also do have investigation powers, and they have the authority to instruct a procuring institution. Let's say it's a government department like DSI or DCDT to fix a problem within that. For example, if someone's not complying with the act, and if they do find evidence of a crime, the Public Procurement Office, or PPO, has an obligation to report it to SAPS. They also have the authority to authorize people to search government buildings without a warrant. For all other places, though, for private sector organizations, for suppliers, they would need a permission or a warrant, and they need to respect basic rights and freedoms. They can take evidence, but must give a receipt and return them when no longer needed. A judge or a magistrate could issue those warrants, but they are very specific and can only be valid for a month, which is a pretty long time. Now, what's interesting about this, the final sections of the law, is that it really speaks about the delegation of authority. So the Minister of Finance is effectively in charge of the implementation of this law from a cabinet position. However, that authority can be delegated to various professionals, not professionals, but different role players. However, the accountability ultimately does lie with that minister for compliance with that act and to whom they delegated. So similar to a company law perspective, where Section 66(1) of the Companies Act says directors must manage the affairs of the company, and 76 onwards speaks about the duties that they owe to the company. Those duties remain with the person who's delegating the authority. More interestingly, from a limit of liability perspective, is that and this was curious for me because limits of liability are typically in contracts, not in laws. There are a few exceptional cases, but it's never specifically outright. And so, what this section specifically says that the people that are referred to in the Act, so in the definition section of the Act, are not legally responsible if their conduct is done in good faith while carrying out their duties. So if someone does something and let's say it's a procurement official or the procurement office or member of the tribunal, they take an action which causes harm, this act specifically excludes their liability. And what this requires from you essentially, again, is to look at your contract between yourself and the procuring institution and know that the carve outs for liability will effectively be curtailed or carved out according to a good faith standard, which is pretty novel and interesting. It may be challenged effectively in various courts, but we need to wait and see on that. Now, I know we have 5 minutes left, and so I just want to wrap up very quickly. But to let you know that there are the accounting authorities will be held liable if they don't implement the law properly. And then there are specific crimes, and this is probably one of the key sections, that these are specific crimes. So if you lie or give misleading information as a bidder or a professional, procurement professional, if you interfere or pressure officials, if you open sealed bids, and so this would apply digitally as well, break sections of the law or cause loss or money. And then there are some lesser offenses which are not serious. And then what I think is also important to note, at least, is that everything under the law, so this entire process that we've discussed, all the work that the procuring institutions do, the Public Procurement Office, the Public Procurement Tribunal, needs to be in writing. And the idea behind that is that there's this sense of record keeping, records retention, and data or keeping data logs essentially to promote transparency and accountability. Now, part of the transition arrangements are that currently, until this law is or the president announces the commencement date of this law, all existing bids will be handled under the old laws. But interestingly, they're taking an agile approach to regulation in that this law will be reviewed every 2 years, and the minister needs to report on it and then decide whether any updates are necessary. So what's next? What actions can you take? Well, we need to wait on the commencement date as well as regulations and other guidance notes, as well as it's predicted that there may be constitutional challenges to it, particularly in the High Court, and particularly in the state interfering with the authority of provincial and local authorities. However, we're yet to see any action being specifically or applications being launched in any courts, or at least nothing's being reported right now. But what can you do? How can you respond to this law? I would say start incorporating it as part of your organization's compliance framework and start evaluating who needs to know about this law or who actually needs to implement it, what functions they need to perform in relation to this law, and align with it as it is as a standard. So think of it like an ISO standard that you would need to comply with. You want to put the principles in place or the controls in place so that when the law does eventually materialize, you have very little to do. And so what I recommend is conducting an impact assessment. I'll share a link to an impact assessment with you guys after the session that me and my team have created, which will essentially evaluate the impact of the Act on your business and what actions you can take from there. Other than that, this is the end of the session for